Hello, everyone. I am joined today by Mel Schwechter. He is a partner at Baker Hostetler, and Baker Hostetler is one of the nation's largest law firms representing clients from around the globe in areas of litigation, business, employment, intellectual property, international trade, and tax. Mel, we're delighted to have you with us today.
Thank you, Rihanna. It's a pleasure to join you.
So, Mel, your practice is built around addressing complex international trade matters for clients. Can you talk about what this means for software companies in particular, and are there any specific risks for software developers, that they face in the global economy?
Rihanna, many U.S. companies distribute software and other technology products globally, whether by physical shipment or electronic transfer. With the rapid development of the technology sectors in many low-cost countries, more and more U.S. companies also outsource their software development abroad. However, what many companies fail to recognize is that in doing so, or by hiring foreign nationals who are not U.S. citizens or permanent residents, they may be exporting technology and software that is subject to U.S. export controls and related licensing and other regulatory requirements that carry significant potential penalties for non-compliance. Software that is subject to U.S. export controls can be of various types, including operating, process, and encryption software. Cryptography is treated as a critical technology and is closely regulated by the U.S. government because of national security concerns and the need for secure government communications and intelligence gathering. While the United States has, in recent years, taken a number of steps to reduce dramatically the number of situations in which export licenses are required for exports of encryption items, as part of that process, it has imposed sometimes confusing requirements on exporters to allow them to take advantage of the license exceptions. In addition, the regulations surrounding exports of software and related technology are in the process of being revamped, with some rule changes taking effect even this week. This necessitates that software developers and exporters take special precautions to stay abreast of the impacts these changes have on their activities.
Great. Now, could you define for us non-lawyers out there what constitutes an export of software and technology?
Sure. While most companies understand that a cross-border shipment of computers or hard drives constitutes an export, the export control laws also apply to exports of encryption and other software or technology items that may not be recognized by companies not experienced in dealing with export controls. An export of encryption or other software or technology occurs when the software is actually shipped, transferred, or transmitted, whether physically or electronically, out of the United States. Covered exports, however, can also take place in other ways. Releases or disclosures of U.S. encryption technology to a foreign national in the United States or overseas, and releases or disclosures of U.S. encryption source code and technology in a foreign country to a foreign national are also governed by U.S. export control laws. These are known as deemed exports and deemed re-exports, respectively. Non-encryption source code disclosed to foreign nationals in the United States is also a deemed export. Furthermore, for some encryption software, exporting also includes the downloading or causing the downloading of the software to locations outside the United States, or making such software available for transfer outside the United States, unless the person making the software available takes precautions adequate to prevent unauthorized transfer of the code, such as by transferring the code to restricted persons or embargoed countries. Under a new rule effective September 1, transmitting or storing non-military electronic data that is 1, unclassified, 2, secured using end-to-end encryption that meets certain encryption standards, and 3, not intentionally stored in a U.S. military embargoed country or in the Russian Federation, will not constitute an export of that data. That means that such exports of technology and software to the cloud will not be controlled for export, provided they meet the required criteria. U.S. export control regulations apply not only to U.S. origin products, software, and technology, but also to re-exports of U.S. origin items, foreign origin items that contain more than a de minimis amount of controlled U.S. content, generally 25%, and foreign origin items that enter the United States before being exported.
Wow. So how do companies ensure compliance with the U.S. export control laws?
First, a U.S. company must determine under which U.S. export control regime the software and technology in which it deals falls. Exports of military software and technology are controlled by the State Department under the International Traffic in Arms Regulations known as the ITAR. Such exports will require licenses for export to almost all destinations. Other software and related technology are controlled for export by the Commerce Department under the Export Administration Regulations. Under that regime, whether or not an export license is required is determined in part by the item's classification. Therefore, the first order of business for the company is to determine the export control classification number under which the item is controlled. These numbers are called ECCNs. The controls for software and technology exports generally mirror the level of control applicable to the equipment they are designed to develop, produce, or operate. So, if a milling machine would require a license for export to China, the software to run the machine and the technology to develop or produce it will also likely be subject to the same level of licensing requirements. Encryption software and technology, however, is generally controlled based on the level and type of encryption involved and will generally be controlled under unique encryption export rules, even if it is incorporated into another item.
Wow. So this definitely these policies have significant impact on the software industry. What have you learned so far in addressing?
They do indeed.
What have you learned so far, Mel, in addressing these issues? Are there things software companies can do to protect themselves? Is there one action a developer could take today?
Companies involved in exporting software, particularly encryption software, should have an export control compliance system and procedures in place to make sure they do not commit violations. That system and those procedures should begin with determining the software's appropriate export classification. Once that determination is made, companies can assess the nature and extent of applicable licensing, registration, reporting, or other requirements, and implement procedures to ensure they are met. Because software products regularly undergo updates that alter encryption functionality, and because encryption controls are likely to evolve further, companies should regularly reevaluate the appropriate classifications for their software and technology, the attendant requirements for export, and their export compliance procedures.
Mel, thank you so much for your advice and insights today. For more information on Baker, Hostetler, and SIIA, please visit our websites and be sure to stay tuned for next week's Executive Spotlight.